correlation with my investment in stocks. It correlates with a negative effect on earnings. In fact, some people actually have asked me what I'm planning on investing in for just that reason.
Jay Schweikert, Harvard Law School. Professor Zaring, you've suggested that maybe we shouldn't be too concerned about the blurring of the public-private line. And my question relates to some of the concerns that Professor Verret has mentioned, but it's a bit more of a fundamental question that I've sadly learned may be a bit of an antiquated question today, but I'll ask it anyway. When talking about the public-private distinction, isn't the fundamental question here, the fundamental distinction, the fact that the public sector is operating on the basis of government coercion and the private sector needs to operate on the basis of voluntary cooperation? And I understand that there may be complicated questions of fiduciary duty or complicated questions of fraud or even voluntariness even of itself may be a bit of a sticky question today. But isn't there still just this fundamental categorical difference between the way that Washington bureaucrats and Wall Street bureaucrats interact in this nature? And shouldn't we really be addressing that fundamental question before going to the specifics of private sector policy or public sector policy?
David, you want to take that?
Sure, I'll give it a shot. So that seems very different, doesn't it? That the government makes you do stuff and has the police power that can force you to do stuff, and the private sector doesn't. I wonder, in a day of increasingly complicated institutional relationships, whether it still makes sense to draw that broad line between public sector and private sector in even the marketplace. Now, I'm no fan of nationalized companies. I don't want to go back to the United Kingdom in the 1970s or whatever. But it seems to me that when the government takes an ownership stake in companies, it has a couple of options. First, it can use that ownership stake to pursue political ends, say give something to a favored union, or manage the company so that it, as Jay suggests, makes loans to battleground states. Or it can try to maximize the return on its investment. The question you're asking is, will it obviously choose the former path? And to me, it's just much less obvious that it'll do so in this day and age. I think the government spends TARP money somewhat cautiously. Well, I don't know about that, but I mean, it's going to pay a political price for losing money on the TARP investment, which it, by the way, surely will on General Motors and Chrysler. But the government's returns are open to all. When companies began paying back their TARP funds with interest, that was viewed as a win for the government. And I don't think that the political process here is the kind of process where you can direct Bank of America to start making loans in Detroit or battleground states, Ohio, without, paying a massive political price for that sort of thing. So if the question is, will the government try to do a good job and maximize the return on its investment, or do a political job and pursue short-term but immediately favored interests? It's not clear to me whether the government won't try to do the former, and it's not clear to me that if they do the latter, whether the long-term givers of the money that the government's deploying, whether they won't hold the government accountable.
If I actually have to say, I would have thought that the question whether politicians would behave politically would be one of those rhetorical questions that you pose. It's sort of asking, whether lions will behave like carnivores. We've had an awful lot of experience over the years with this, and I would have thought that was one of those questions that wouldn't be readily debatable. David, you want to jump in?
I think you're asking, your comments go to the question of whether this will work well or not. I mean, in your opening remarks, you said, there's no reason to think it won't succeed. It appears to be succeeding. But I think we also need to focus on the question of, is it legitimate, and who decides. We are, after all, talking about billions and billions of dollars of taxpayer money, and it may work, but we're counting on a very small group of people with almost no direction to make the decisions, and they may do it in a way that we look back and say, well, it all seemed to have worked, but there's no guarantee of that, and there's no consensus or anything approaching law that governs how they're spending this money.
Quickly, I think there's another aspect to this, lessons learned. We have the government-sponsored enterprises, Fannie Mae and Freddie Mac, which had private investors and, of course, government guarantees. For 40 years, they did a lot of very good work, but look what happened the last 5 years of that lifespan. We, the taxpayers, are very much holding the bag. Now, they had a legitimate government purpose, but the profit motive, if you look at the loans that ultimately brought the companies down, Fannie and Freddie were trying to compete against the private sector, particularly in the Alt-A or subprime marketplace, and those were the first portfolios to go bad. And it's an interesting hybrid of the question, you know, public role versus private role in a hybrid type of organization, which Congress will be turning to as they try to figure out what to do with Fannie and Freddie in the coming year.
Hi, Mark Holmes of the U.S. Tax Court. I have a question for which I hope either Professor Zaring or Dean Cass have an easy explanation. But at what point, or is there a point at which a corporation that is controlled by the federal government becomes an authority of the United States and thus an agency under the Administrative Procedure Act?
Now, do you have tax court funds to pay for the answer to that question?
So this is that's an excellent question, and one that I don't claim a lot of knowledge over the answer. So the federal government occasionally charters corporations on its own dime, and those corporations are different than the agencies or other instrumentalities of the United States. And to give you an out-of-date example, I think ComSat, the satellite corporation, was an example of a sort of federally chartered corporation. Amtrak is a federally chartered corporation, I believe.
This is yeah. I'm sorry, I didn't mean to interrupt.
No, go ahead.
I was just going to say, this is sort of the point of the Lebron case that I mentioned, which Justice Scalia examined whether Amtrak was the government for purposes of the Constitution, despite the fact that when Congress created Amtrak, it's expressly said it's not a instrumentality or agency of the U.S. government. Justice Scalia said that's well and good for statutory purposes because Congress gets to decide statutes, but as we'll decide whether it's a constitutional, for constitutional purposes, whether it's the government or not. And that's sort of my point. In my remarks, one of the points is, you know, when this has happened before, Congress has actually considered this question, and some corporations that it's involved in or creates, it decides to make them government agencies, like the Overseas Private Investment Corporation, I believe, and others it expressly says they're not, and it makes decisions about these things based on its policy judgments and you know, hearings and process. We don't really know the answer to what AIG is or GM or Chrysler, at least in terms of what the Congress thinks. So it'll be left to the courts ultimately to make some of those determinations when these lawsuits are brought.
I'll add to that so what about a corporation that sells essentially only to one outfit, and that is makes all its money from a, say, government contract, like a private prison or something like that? My sense is that the courts have been somewhat unwilling to hold those sorts of corporations liable under, say, Section 1983 or Bivens. So the answer is clearly quite complicated.
I think I would definitely agree with that. I think one of the distinctions about the present circumstance from the corporate law side of things is that the history of government corporations has either involved federal chartering or state chartering, in which the government owns equity, but it's not publicly traded. But the perfect storm that really creates all of these circumstances that are my focus are publicly traded, state chartered, and government ownership. Right, so you know, like Fannie was publicly traded, but the government didn't own shares. So I think those unique circumstances all coming together really throw a wrench in everything we know about corporate securities law with respect to TARP recipients. I think that's the big issue.
So the short answer to your question, Mark, is that the situation is good for lawyers and bad for investors. Yes.